Welcome to Acres Financial Group Winning in Retirement Classroom session. Welcome to our fourth one. Thank you very much for listening to the ones that we've been posting up. Remember that at acresfinancial.com under our webinar tab, you can see all our past webinars that we have done in this series. We have a few more weeks to go. Every 2 weeks on Thursday at 4 p.m. we'll be showing the live version of the topic that day. And then what happens is it goes to our website. It'll be available for you to view at later dates. You can also have the ability to send it to your friends for them to watch and hear the great speakers that we put together. Usually we've been having this at Water's Edge with our Retirement Expo, which we had for 8 years in person. We're a little disappointed this year that we had to reschedule so many times, but we wanted to deliver the information that we had put together. We had great speakers. We wanted them to come to you and be live and really talk about the topics that we need about retirement this year. So this classroom session today is going to be like the others. We have prizes for all the new people. We have the amazing Acres Financial Notebook. You need this. And by signing up for today and being part of the live video, what happens is we're going to be mailing this to you very, very soon. And of course, we have the lovely I can never say the right word. I think it's microfilm. Actually, not microfilm. It's a microfiber piece of cloth that you can wipe your glasses with, which is amazing. And it has the Acres Financial sponsored sunflower, which is beautiful. And we all need one of those. And of course, we got the amazing Winning in Retirement jar opener. You cannot do without this. If you don't have one of these, you must. If you need two, why not? We have a large box of these in case you would like extra for Christmas. But the Acres Financial Winning in Retirement, that's our radio show on Saturday mornings, 11 a.m. at 105.7 The Fan. You can join us there every Saturday morning. And of course, our radio tab, acresfinancial.com, you can actually listen to the former shows that we have. Now, this show, this live video is available to you. And on the right box is a thing called a chat box. In that chat box, you can communicate. One of the team of advisors from Acres Financial Group is there and can answer your questions as you talk today. As we bring in a special attorney that we're introducing to you guys today, I've known Kevin Bress for many years as an expert attorney around Maryland. He lives in Bel Air, Maryland, and he has an office in Bel Air and in Towson. I wanted to talk about his topic a little bit today. Let me read it to you because I want you guys to understand this. It's the Maryland's fabulous new protocol for uploading your medical directives. The problem is no one knows about it. So you need to pay attention to this. This information is information that will help you organize your estate planning when it comes to working here in Maryland. So Kevin Bress, we're going to invite him up to the stage. Thank you for coming today. Here's Kevin.
Thank you, Brian. Thank you, everybody, for tuning in. I'm Kevin Bress. I'm an attorney who's been practicing in the estate planning field for, I hate to say, 35 years, and mostly in this Baltimore area. Estate planning is like a three-legged stool. You have your will, you have your power of attorney, and today we're going to talk about the third leg, a medical directive. And I think most people are familiar with that concept. The document does two things. Who makes medical decisions for you if you're unable to do so? Why would you be unable? You're unconscious. You're rushed to the hospital. Or you're even taken in for just a routine procedure and you're all drugged up with painkillers and so forth. And so you need a family member to be able to make critical decisions with the medical folks at the hospital. The second aspect of that document, what powers are you giving your family? And you need to say in there, for example, a critically important one is HIPAA, the Privacy Act. A spouse has no right to learn about their other spouse's medical condition under the law unless there's a HIPAA waiver. The medical directive takes care of that. What about the old term we hear, pulling the plug? Meaning no more life-sustaining procedures. Do you want to give your spouse or your adult children the power? That sounds a little dangerous, right? The power to pull your plug. But we all know there are critically terrible situations where you don't want to be kept alive any longer. Let's talk about a 99-year-old person everything's failing, they're in pain from arthritis, they're going to say, look, the next thing that can take me out, please let it take me out, like an infection, pneumonia, COVID. So how do you express that? You need to put it in writing. Now, here's the newer part in Maryland. And Maryland's getting pretty cool with some innovative ideas they're doing. You sit down, usually with a lawyer, and we draft up your document. You sign it. It gets witnessed by 2 people. And then you walk out the door with it. And you're saying to yourself, well, what do I do with this thing? If you're rushed to the hospital, the first question coming into the hospital is supposed to be, do you have a medical directive? Well, you're on a gurney, half out of it, no medical directive. So now the hospital doesn't know who's in charge. They don't know what authority they have. How do we get around that problem, short of taping it to your back? Nobody's going to do that. Maryland spent years developing a system that was completed about 1.5 years, 2 years ago, and it lets you upload your document to I hate to say the cloud, to a site that then links to all the hospitals in Maryland. If the hospital types in your name and date of birth, they can download your medical directive like that. Better than that, on this website, you can also put in critical family members' names, phone numbers, email, so that if you land in the hospital on an emergency, they know to pick shock trauma. They know to pick the phone up and get a hold of your daughter, your wife, whomever. So I need to tell you how to do this. It's free, and the state of Maryland, the Department of Health, set this up, and they've done zero to market it, to advertise it, to get people to do it. So I'm beating the drum, one person at a time, but thanks to Acres Financial, I'm maybe reaching a few more people, so that's great. The magic website you want to go to is mydirectives.com, mydirectives.com. The first screen is going to ask you to create an account. And all you need to create an account is to give them 3 pieces of information: your name, your date of birth, and your email address. So it's not exactly something you would worry that a foreign country is going to hack into this and they're going to get all your personal information. No, name, date of birth, email. They probably already have that. So what you need to do is convert it to a PDF. If you don't know what I'm talking about, by calling it a PDF, look for someone in their 20s to help you out, to get your document scanned into a PDF. I kid you not, I had a client and I said, I need you to put this into a PDF so you can upload it. The client said, can you mail it to me, the PDF? So I said, no, I can't mail you a PDF. I can email you a PDF. So you might need a little help with that clunky part. But the next thing you want to do when you're in mydirectives.com is drag the PDF into the page where it says upload documents. You're virtually done at that point. My caution with this mydirectives.com is that they do ask you voluntarily to put in a lot more information if you want to. Personally, because I did it for myself, I did not put in any of that information. It was asking religious beliefs, and it was kind of like you're talking to a doctor in this document. And I felt like, I'll let my family talk to the doctor. I'm not going to do it this kind of weird way through their site. They're trying to be helpful, I get it, but you don't have to feel compelled to do that. Especially the screen that says, to verify your identity, you may enter your social security number. And that was a deal breaker for me. I reached out to the CEO of the company to say, you got to get that off of there. But they added the word optional. I wish it wasn't there at all because people are going to be intimidated. I'm not putting my social security number out there. So the mechanics of this are as follows. Once you upload and you set this up, the state of Maryland lets mydirectives.com link to something that's called the Maryland Health Information Exchange. This Health Information Exchange has been around for years. We consumers don't know anything about it because we're not involved in it. The exchange is between doctors, hospitals, nursing homes, ambulatory agencies, and so forth. What that exchange does is it lets your chart, your medical information be shared with these different healthcare providers. Well, now your advanced directive is available to download into the Health Information Exchange. Here's a nifty part of this. In the My Directives website, if you go back into your login, it shows you who has downloaded your medical directive. And for me, it better be nobody, because fortunately, I've not had a visit since I uploaded my document. So nobody should be looking at my directive, but it will tell you who accessed it. That's kind of neat. It also reminds you annually, mydirectives.com will shoot you a note and say, please renew, it's a year is up, please renew your subscription, your membership, your belonging to mydirectives.com. And that also is a good forced way to kind of, let me read what I put in there. Oh, my daughter moved, I better change that. So it's very well conceived. Maryland paid a couple $1 million to get this up and running. Other states have similar things. I called Florida Department of Health. They said, no, we don't have it yet, which they said is surprising because Florida is the mecca for retirees, seniors, and they don't have it. So if you go to Florida as a what's it called? A sunbird? Snowbird. I'm glad the producers are standing here to cue me. If you go to Florida as a snowbird, in theory, you should have a different medical directive for Florida. And if you go cross country, you should have one for each state because each state's laws and concepts and things are different. But at least with the mydirectives.com, you have the ability to pull that up even on your phone and show it to the health provider and say, I'm here for my mother. Here's her directive on my phone. Is that acceptable? Who knows? But it's better than nothing. So that is my advice to everybody is check out that website. It's fantastic. If you go through your drawer to see what you have as a medical directive, I would caution you that if you have a document called a living will, read it carefully and you'll probably tear it up. The old-fashioned living will says, if I'm in this condition, I don't want to be kept alive. You may withhold food, water, medical care, and it's like a directive to the doctor to kill you. I'm exaggerating, but in a sense, that's true. Why is that such a bad thing? Because the new regime is the directive that you upload to My Directives. It's a document that lets the family be in charge. The old-fashioned living will, the physician was in charge. Now, is that a bad thing? You don't even know who the doctor's going to be. It could be a new resident. It could be somebody who the family thinks doesn't know what they're doing, and yet they read that living will, and in theory, they're like pushing the family out of the room and saying, we got to pull the plug. This guy said if he's terminal, he doesn't want to be kept alive. So you can see the living will can be pretty problematic. It's more of a medical directive now that we're encouraging everyone to do. The new form in Maryland also is called a MOLST form, M-O-L-S-T. It stands for Medical Orders for Life-Sustaining Treatment. The advanced directive ties to the MOLST form. Here's how. You may have heard of the old-fashioned form. It was called a DNR, a Do Not Resuscitate. And it was an actual state of Maryland form that was signed off by a healthcare professional. But it was very limited. It was one page, and it was about resuscitation. The MOLST form is multiple pages, and it gets into many more aspects of keeping somebody alive, like, do you want a blood transfusion? Do you want kidney dialysis? Would you want to be intubated? We're hearing a lot about intubation with COVID and ventilators. And it comes down to antibiotics. You can actually, on a MOLST form, refuse antibiotics. Now, most of us are hopefully healthy enough that we're not going to be checking off, kill me, kill me, kill me. But this MOLST form makes your wishes known, and the doctors must follow it. It's a medical order. You can complete your MOLST form with your healthcare provider, but they probably won't do it unless you're ill. Here's my dilemma. What if you're rushed to the hospital? You're unconscious. They have your health directive. They download it from mydirectives.com. The family comes rushing in and they pull out a MOLST form and they hand it to the family member and say, you're the healthcare agent. Fill out your father's MOLST form. And the child says, I don't know what he wants. So the final piece of this puzzle, my directives, MOLST, is a document that tells your family what your wishes are. Intra-family document, not legal, not binding, not given to the healthcare people, but simply instructions. In my 35 years, I finally crafted one that I think works really well. I've seen something on the web called My 5 Wishes, and I certainly looked at that and incorporated that into my document. You can write your own. There's nothing magical to it. The one I wrote kind of coordinates with the MOLST form. So it's like they're taking a test when they have to fill out the MOLST form, but you give them a cheat sheet with all the answers. Check this, check that. I don't want this, I don't want that. So that's the takeaway for today is please get your updated advance directive, get it uploaded, know what a MOLST form is. You can download one from the internet for Maryland. Just type in Maryland MOLST PDF, and chances are you'll get the document that you can download. And with that, I'm going to share the stage here with Brian, and thank you.
Thanks very much, Kevin. I know it's hard to talk about the hard things, but in financial planning, what we want to do is this. We want to prepare as if something's going to go wrong tomorrow. You invest and make your money last a lifetime, but we have to have all these documents in place. The sad part is many of our clients, when they come in, don't have these documents in place or updated within the last couple decades. So while I have Kevin here, I am introducing you to Kevin today, but Kevin has been around a long time, and I'd like to welcome you to Acres Financial Group when it comes to talking to our clients, which is wonderful to have you talk. These things like the MOLST form, that's MOLST. We're also going to have the link tied to the chat box as you're listening to and watching today. You're also going to have it on acresfinancial.com for you to be able to get the document there. On the website, it says documents, so it'll be available there so you can see what to do about it. Then, of course, we'll have some information about Kevin and how to reach his office at pklaw.com.
That's exactly right.
All right, so I got a tough question for you. All right, so let's say if I passed away and I had a car in my name, and that's like the only thing that's going to be in my estate because I've done other planning. Is there any way around that kind of problem?
Yes.
What would people do about that?
The best thing they can do is go to the MVA website, Motor Vehicle Administration website, and check Vehicle Beneficiary Designation. And you can actually type in a beneficiary of your car.
That's a common problem. When people pass away, they say, oh, mom had a car. And what do I do with that? We have to open the estate, a small estate, just to get that transferred over. So it's a form on the MVA website. What is it called again?
Well, Google MVA eStore, like E-S-T-O-R-E.
Okay.
The page that comes up on the left column will say Vehicle Beneficiary Designation. Okay. Click that. It is $20 because they're going to mail you a new title. It doesn't make a co-owner of your car. it makes a beneficiary of your
Oh,
car.
that's excellent. Yeah, very excellent. So what we want you to do today is understand this information about healthcare directives, the mydirectives.com, the MOLS, these documents that a lot of times we don't think about. Now, there's an important date. Was it October of 2012 when Maryland started to change some of the laws when it came to healthcare directives?
Well, I thought you were alluding to the October 2010
Okay.
power of attorney.
Oh, okay. Our attorney changes.
Power
right?
of attorney changes. So if you have a power of attorney pre-October 1, 2010, it's not good.
How about healthcare directives that are older? What do you say about that?
Well, certainly the living will was something I'd love people to tear up. And I love newer ones that refer to HIPAA and refer to the most form. Those are kind of the newer important things to be in your directive.
Right, and that's excellent information. Thank you very much, Kevin, for coming today. Really appreciate you coming out and talking with us.
Great to be here.
No problem. All right, thank you guys for listening so far for our talk today. We have more speakers in just a moment. Welcome back. For those who did not see the beginning, I learned a new word today, and that's microfiber. That's one of the gifts that you can get by signing up for our video today. We'll be sending that to you very soon. Thankfully, you've been listening to our estate planning day. We had our local attorney, Kevin Bress, talk about many different topics about healthcare directive, MOLS, and mydirectives.com. And the second half here, we have our national attorneys, Mark Perkins and Jennifer Eseed. They're going to talk about estate planning essential. Mark Perkins has the book, Your Life, Your Legacy, which we have available if you'd like to have a copy of that book. We also can get you more information. Whatever they speak about today, when it comes to topics or anything that interests you, we can get you more information. You can get it just by calling us at 410-692-9870. Now I want to introduce you to Mark Perkins and Jennifer Eseed, and here they are.
Hello, my name is Mark Perkins. I, along with my colleague, Jennifer Eseed, are going to talk to you about estate planning and how it relates to your own estates. I've been practicing for 30 years and mainly in estate planning. Jennifer not only does estate planning, but also business planning and elder law as well. The first thing that really, to understand estate planning, you have to understand probate. And probate comes from the Latin word probo, which means to prove. And so probate really was designed to prove who gets what, how, when, and where. So there are some problems with probate. The first problem is that probate can be time consuming. What happens is when someone passes away, the will has to be filed in probate court within 30 days of death, and that starts this whole probate process. By law, probate has to be at least 6 months in length. It cannot be shorter than 6 months. But typically it's 1 to 2 years. It can last decades, doesn't happen often. But for example, Elvis Presley, Marilyn Monroe, all had more than 10-year probates. Or like John Wayne, he died in 1979 and his probate didn't end until 1991. So once that will is filed, it becomes a public record. Anyone can go walk into the probate court, can read the will, who got what, how much they got. It's all right there. So it is a public proceeding. Also, as the court proceedings go, anyone can walk in and watch the court proceedings. Don't even have to be related. Don't even have to know who the person is. You could just spend all day in probate court watching people going through probate. And so because of that, there are sometimes people who come in to contest a will just to cause basically a frivolous lawsuit to get more money out of the estate, whether they're heirs or not. There's even people who've come in, not even an heir, just contesting the will, and then the family has all the burden of proving that the will is valid. The one contesting doesn't have to prove anything. And you could have multiple probates. So if you have assets outside of your state, so let's say if you had real estate in other states besides Maryland, then you could have probate in those states as well. So I'm going to talk about wills and really specifically how wills really relate and how they work through probate. Again, as I mentioned, You have to file the will within 30 days in the probate court, and that starts the whole probate process. Therefore, wills guarantee probate. Of course, a will does not take effect until you pass away, so therefore, nowhere in the will can you say what happens if you should become mentally disabled. So a will cannot cover you while you're alive. And therefore, you have what's called living probate. Living probate means if you become mentally disabled and all you had was a will, or let's say you had your assets in joint tenancy, or like a husband and wife that had wills, joint tenancy, the husband's in a car accident, he's in a coma, and the wife decides she wants to sell the house. She can't sell because the will hasn't been activated yet because he's still alive, but he has to sign, because he's still alive, he has to sign as the joint tenant. And so he can't, and then she has to go to living probate court to declare him mentally incompetent and become his legal guardian. Now that can be time consuming, it can be expensive, it can be embarrassing, but there are ways to avoid living probate, and Jennifer will talk more about that in the second half of our presentation, more dealing with powers of attorney and living trusts. But again, you cannot avoid living probate or death probate through a will. So here's actually a picture of Groucho Marx going through living probate court. So maybe you remember watching it on TV or reading about it, but when Groucho Marx was going through living probate, his girlfriend Erin was contesting to try to take over his estate. And his family was fighting against her, preventing that from happening. And they said that most days when he went to court, he had tears in his eyes because he was so embarrassed and humiliated by this whole process, which took about 3 years, about a 3-year proceeding. In the end, the family did win, but the sad thing was he died about 5 days later, and that could have been totally avoided had they done some proper planning. So once again, wills are fully public. The will's filed in probate court, anyone can walk in, they can read your will, they can see who gets what, so it guarantees probate, and therefore, again, can be very easily challenged by heirs or even non-heirs. Anyone can walk into the probate court and say, I contest, the family that has all the burden of proving that the will is valid, that the person was of sound mind, etc. And of course, if you do your will in Maryland, you move to a different state, every state has their own laws regarding wills and regarding probate. So it'd be a good idea to have that will checked out in the state you move to. So now we're going to talk about estate taxes. And estate taxes really deals with what happens when someone dies and if they have their estate over an exemption amount. Well, if all you did was a simple will or joint tenancy planning or bare bones living trust, you won't avoid the estate tax. There is a marital deduction, so if you are a married couple and you are American citizens, then you get an unlimited marital deduction that can pass to your spouse with no estate tax at the first passing. But when the second spouse passes away, there is an estate tax, at least in Maryland, if your estate is over $5 million. Now, if your estate's over $11.58 million, then you would also have a federal estate tax. So now we're going to talk about estate planning with a properly drafted, fully funded living trust and how that would work. So basically, a trust is a separate entity that you create. It's called a living trust because you create it while you're living for the living. In fact, the Latin term for it is inter vivos or inter vivos trust, which literally means from the living to the living. So you create it while you're living, and the document then states how to take care of you while you're alive, and it talks about how to take care of your family members after you pass away, of course, while they're living. So it is a legal entity that can possibly operate indefinitely. So if you're Joe Smith and you're doing a trust, you're probably going to call it the Joe Smith Living Trust. If you're married and you do a joint trust, you probably call it the Smith Living Trust. Or if you're married and you want to do separate trusts, you could have the Joe Smith Living Trust and the Mary Smith Living Trust. All depends on what kind of estate plan you want to set up. And Jennifer is going to talk about that more in detail here in a few minutes. But the main thing is that it's all in place. So if you become mentally disabled, and believe it or not, we're 4 or 5 times more likely any given year to become mentally disabled than we are to die. So you really have to plan for that. Of course, when you pass away, also it covers you to make sure all your assets go the way you want it to go. So the trust then is in place to make sure all your wishes are covered. So living trusts will avoid probate as long as it is funded, meaning a trust is a separate entity. And so when you create your trust, let's say the Joe Smith Living Trust, and you transfer the title of the asset from Joe's name into the trust name, now Joe no longer owns that asset, the trust does. Or maybe the trust is the beneficiary of that asset. So now when Joe dies, there's nothing to prove because nothing's left in his name. It's all going into this trust name. And therefore, when he dies, there is no probate. Again, probate meaning to prove, so nothing to prove. So the key thing then is making sure the trust gets funded. And so yeah, this next slide, at this point, Jennifer is going to talk about how funding is crucial, and she's going to talk more about trust, as well as Dynasty Trust and even IRA Trust.
So as Mark mentioned, when you're funding a trust, you're retitling assets into the name of the trust, or you are naming the living trust as a beneficiary of those assets, really depending on the type of asset and your goals. You could have the best trust drafted, with all of the estate tax planning, asset protection, everything you can think of. But if your assets are not properly moved to that trust during your lifetime, then those assets still will go through probate. And funding is really the crucial final step to creating a living trust-based estate plan, and where you can really rely on your financial advisors who can really do a great job. So this is why we rely on people like Brian to make sure that on the back end, the estate plan that you've put into place really is doing the job that you wanted it to do. The trust itself is ineffective until it's funded. So unless assets are in the trust, it's just an empty document. We also prepare pour over wills. So Mark spoke a lot about wills and how wills don't avoid probate, but should you fail to move an asset into trust, we will still do a backup plan for you, still do a simple will that says any of those assets that might have been left outside should be transferred to my trust. So, we can still kind of have this safety net, but it's not something that you want to rely on. Your trust does not contain a list of your assets. So when we say funding your trust and moving your assets into trust, we're not writing a list at the end of the document that says you've got, a savings account at this bank, a brokerage account here, a piece of property in this state. What does say is in your trust is the actual titling of those accounts and the deeds of those properties. And what's great about not having a list of your assets is it means you get to move assets in and out of the trust over time throughout your lifetime without needing to come back to the attorney to make changes. The way a living trust works is you as the trustor create and direct the trust. So the trustor is sometimes referred to as a settlor, a grantor, trust maker, but this is all the same role, and it's you creating your own document and putting in all the instructions that you want to be followed if you are incapacitated and after you've passed away. Although you're moving all of your money, your real estate, etc., into your trust, you stay in that second role, the trustee, managing those trust assets as long as you're living and as long as you have capacity to do this. You've also, ahead of time, named your successor trustees. So your successor trustees are the people or even a corporation that you've decided that will take over on your behalf if you are incapacitated and then after you've passed away. So that's, let's say, you've named one of your children to be a successor trustee. That's a person that you've named to make decisions for you for your benefit if you're incapacitated, and then the person that you've named to distribute all the assets, pay expenses, etc. after you're gone, fully outside of that probate process. The beneficiary is the role that everybody wants to be because that's the person or people or charities who get to benefit from the trust assets. So again, while you're living, you are the only beneficiary of your trust. you're a married couple, typically both spouses are the beneficiaries of that trust. And even if you're incapacitated and cannot be the trustee anymore, you're still the beneficiary of that trust while you're living. That's the person, people, organizations who receive principal and income according to your rules and what we've written into the trust for you. And then after you're gone, you've named who the beneficiaries are after you've passed. And what's really important about a living trust is that it's revocable. So that means we can make changes to it over time. You can amend it as many times as you want. You can change beneficiaries. You can change successor trustees. You can add in asset protection over the years if you find that that's actually something that you've needed, as time has gone by. So living trusts are important for all types of people. As soon as you own a piece of real estate, you typically want to start talking about a living trust-based estate plan to avoid probate. But for somebody who's not married, a living trust can be even more important because there's no legal partner that is automatically named in the law to step in and handle financial or medical affairs for you if you're incapacitated. So for somebody who doesn't have a spouse, there's no priority role necessarily there for somebody to step in and be able to make those medical decisions for you if you can't make them yourself. And that's where we talk about doing a trust and doing a power of attorney, so medical power of attorney to name that person to make decisions on your behalf. It's the same idea for financial matters. So you don't have a set person to make financial decisions for you, pay your bills, make decisions on your investments when you can't do so for yourselves. Oftentimes, married couples already own things jointly, so at least there's some protection there to have a second named person to automatically make decisions. But with someone who's not married, it's really important to reevaluate that and know who you've decided to name as your decision maker, rather than have a group of people try to step in and argue over having that priority role when you're not able to make that decision anymore. If you are a married couple, then there's two basic types of trusts you can do. You can do two separate living trusts, or you can do a joint trust. And either way has its pros and cons. And so two separate trusts can be used in a situation where you have possibly different beneficiaries from each other, you want to have additional asset protection, or we're doing it for estate tax planning purposes. So two living trusts means that each spouse has their very own trust. You are the trustee of your own trust, you're the beneficiary of your own trust, and then sometimes you will have your spouse also as the trustee and beneficiary of your own trust, but that can be circumstantial and you get to make those decisions. Two separate trusts fully avoids probate as long as it's funded, and it preserves a deceased spouse's $5 million Maryland estate tax exemption. So Mark spoke earlier about estate tax planning and said, if you've got a bare bones trust or if you have a will, you're doing nothing to plan around this estate tax. But if you have two separate trusts and your estate together is worth over $5 million, then you're actually each able to use up a full $5 million exemption, double that state estate tax exemption, have $10 million in Maryland to pass on to your children without estate taxes. And so we strategically fund each spouse's trust to make sure that's possible. And federally, the number is much higher. It's $11.5 million per person. So that doesn't apply as often. And if you're planning for Maryland estate taxes, we're automatically planning for federal estate taxes as well. The other great thing about having two separate trusts is that it gives asset protection to whoever that surviving spouse is. So when one spouse passes away, his or her trust becomes irrevocable. So when I said earlier that you get to make changes over time, you change beneficiaries, you change trustees, that's not the case for a spouse's trust and that when that spouse has passed away. Now, the surviving spouse can make changes to his or her own trust, but she can't make changes to a deceased spouse's trust. So that stays irrevocable, it's locked. And what's great about that, even though it doesn't have as much flexibility, is it means that the surviving spouse can get married and file for a divorce, can have any creditors, be sued, file for bankruptcy, but this money in her deceased spouse's trust stays protected. Married couples can also do a more simple plan, and that would just be a joint trust. So the two of them can come together and make one trust together. This would be a reasonable and good plan if your estate together is well under $5 million. A joint trust would provide automatically for both spouses while they're living, while either one of them is living. So if one spouse passes away, the surviving spouse continues on with that trust as if it was always her own. And she can make changes, she can make amendments, and she gets full control over the funds in that trust. It's usually a good plan as well if you've got the same set of beneficiaries. So if you have joint children, you completely agree on who you want to be in control as trustees. You completely agree on who you want to receive the funds after you're gone as beneficiaries. Then having a joint trust can be a good plan. A joint trust, just like two separate trusts, also avoids probate. A dynasty trust is another type of living trust that provides for a lasting legacy for your descendants. And this is a great type of plan if one of your goals is to pass on wealth generationally. So it allows you to provide funds for your descendants' needs, and typically it'll be that income can come out of the trust annually, and that the principal of the trust is only distributed to kids, grandchildren, and so on, based on the instructions that you put into the trust. So it might be for specific purposes. It also avoids estate taxes for future generations. So let's say we have a $12 million estate for a married couple. You know, when both of them pass away, there will be some state estate taxes due, but the remaining money continues to grow after estate taxes are due at the spouse's deaths. The money continues to grow generation after generation, and at no level do children, grandchildren, or so on have to pay estate taxes again. It also provides significant asset protection for your descendants. So this even means if you have a great-grandchild benefiting from this Dynasty Trust, and that great-grandchild gets married and divorced, that money is has full asset protection. And so, you know, an ex-spouse, and a creditor, etc., cannot come after your money, you know, down the line. So here's an example of a couple, Bob and Pat, and they've created an estate plan together. They've decided that two separate trusts was a good idea for them, and they wanted to create a dynasty trust for their children and grandchildren. Both of their trusts say that the trustee has to take care of me during my incapacity and also take care of my family. So Bob and Pat want their trust money to take care of each other and possibly even descendants. So it might say that if I've got minor children or even adult children, you can allow for the trust to take care of them if you don't have capacity. And of course, we also want the trust to take care of your obligations. So if Bob and Pat don't have capacity to make their own financial decisions or medical decisions, we want to make sure that their trustee is paying those medical bills, is paying their taxes every year, and taking care of all monetary obligations that they have. If either Bob or Pat pass away, and here let's say Bob has passed away, his trust becomes irrevocable. It's locked. Pat can't make any changes, but Pat can benefit from that trust for her lifetime. After Bob and Pat have both passed, each of their trusts splits into 3 sub-trust shares. So their children, John, Peter, and Susan, each get their own dynasty trust, their own trust share from their parents' trusts. And each child can be the trustee of his or her own trust share. So that would provide for a lot of control and flexibility. So John would have his own trust share, but John would also be the trustee of his own trust share, and so on for each of the kids. The parents could also set it up where they have a separate person or corporation in charge as the trustee, which might increase asset protection, but decrease some of the flexibility. So those are just some of the things we would talk about, and are always individual decisions that get made. The assets in John, Peter's, and Susan's living trusts and their dynasty trust shares have significant asset protection from their creditors, lawsuits, divorces. And these assets get to continue to grow and pass on to John, Peter's, and Susan's children for generations without their children, grandchildren, etc., paying estate taxes. So everything we've been talking about with the living trust is really for all types of assets that you own, except for IRAs and 401ks. So Mark and I have been talking about things like real estate, brokerage accounts, savings accounts, business interests, even life insurance. All those types of assets can go through a living trust. But what we don't typically want to go through a living trust are IRAs and 401ks. With an IRA or 401k, you either want to typically, and this can depend on the situation, but typically we're naming beneficiaries directly, or we're creating a completely separate type of trust plan called an IRA Inheritance Trust. An IRA Inheritance Trust is another type of revocable trust that you as the IRA owner create, and you name this special trust as a beneficiary of your IRA. So at your death, the money from the IRA flows through into this IRA Inheritance Trust, and it is a separate document from your living trust. So you might have heard of the Secure Act. It passed in December of 2019. It's called Setting Every Community Up for Retirement Enhancement Act. And it made a lot of changes to the laws governing IRAs and 401ks. But one of the biggest changes in the Secure Act were the rules surrounding how beneficiaries inherit IRAs. And prior to December of 2019, if somebody passed away, their beneficiaries of the IRA could stretch out those IRA payments through required minimum distributions over the beneficiary's lifetime. So if a beneficiary was 30 years old, that beneficiary could take out payments until they passed away. So maybe for the next 60 years, they'd be taking out small payments. Well, the IRS needs their money, wants their money sooner, and they said 60 years is too long to defer taxes. We are going to limit that to a 10-year period. So now for any beneficiary who inherits an IRA, they need to take out the full distributions of your IRAs over just 10 years instead of that lifetime stretch. And of course, because we like to do this in any law, there's always exceptions to the rule. And so the exceptions to the 10-year period are these 5 types of eligible designated beneficiaries. So an eligible designated beneficiary is a surviving spouse, it's the IRA owner's children who are under 18, it's a disabled beneficiary, a chronically ill beneficiary, or a beneficiary who is less than 10 years younger than the IRA owner. And in any of these cases, instead of the 10-year rule applying, we now have a stretch rule applying. For children, it's not a full stretch. Children under 18, it just means that the 10 years starts at 18, so we get to defer it. But for the other 4 categories, we're back to the old rules with a lifetime stretch. And so what we want to be careful of with is if you have a beneficiary who is an eligible designated beneficiary, you really want to have a consultation and talk about whether an IRA trust makes sense for them. And an IRA trust can make sense for any beneficiary to at least encourage or require that they stretch payments to 10 years. But especially if you've got a beneficiary in any of those categories, we really want to make sure we're sending it to them properly so they can still go back and take advantage of that lifetime stretch. Under the Secure Act and with an IRA trust, the way it works is an IRA owner will pass away, and then the distributions are either paid directly to the beneficiaries by first coming from the IRA, going into the IRA trust, and then flowing straight to the beneficiary, so the beneficiary pays taxes on their own tax return. Or option 2 is we get the money from the IRA, goes into the IRA trust, and it's held in the trust. And when the money's held in the trust, that provides asset protection, but it also means typically that a greater level of taxes are paid at a higher level. We still definitely want to go with option 2 if you've got any special needs beneficiaries to protect other benefits though. So this option really allows for a lifetime stretch, plus ensuring that beneficiaries continue to receive benefits over their lifetime that are other, non-related to this IRA. So when you have IRAs, and if that's where a lot of your savings are, you can think of it as having 3 different options for naming a beneficiary on those accounts. Option 1 is the easiest, probably the most common. You name the individuals directly as the beneficiary. If you go with option 1, where you just name your individuals directly, they do have a possibility of a 10-year stretch. So that beneficiary would just have to know that the 10-year stretch is an option. They'd have to reach out to your advisor and say that's the option they want to take. And then they can stretch out payments over 10 years on their own. But there would be no asset protection here at all. And if they are an eligible designated beneficiary, there could be other issues at hand, such as loss of other government benefits. Option number 2 is you can name your living trust as a beneficiary. So we spent a lot of this presentation talking about your living trust and how that relates to your non-retirement accounts like real estate and other investment accounts. But we do see a lot of people come in who have living trusts already listed as their beneficiaries on their IRAs. And what that means is rather than the 10-year rule, the stretch out might actually be limited even further to a 5-year rule. However, there could be some asset protection there. So if you've got a Dynasty living trust, you are giving your kids asset protection, but you're losing out on half of the stretch that the Secure Act is allowing your kids to take or your beneficiaries to take. And the third option is having an IRA Inheritance Trust as the beneficiary. An IRA Inheritance Trust essentially gives the best of both worlds. It allows for your retirement funds to be stretched out to the maximum level allowed by law. So right now that's 10 years, unless you're an eligible beneficiary. And then it also provides for asset protection. So the entire time that the IRA is being distributed to the trust, and if the money is held in trust for the beneficiaries, there is significant asset protection there over those funds. So we've spoken a lot today, about estate planning, and I've really tried to lay out a few different options. You could have a will-based estate plan, you can have a trust-based estate plan, and if you have IRAs, you at least need to be having that conversation with, what are my best options, or what are my options that I can put out there for planning for my IRAs and for my beneficiaries down the line. But ultimately, what you should know is everyone's situation is different. And when we meet with clients, we really dig down into each of your situations and planning the estate plan that works the best for you. So we'd love to hear from you. If you have questions about this presentation, feel free to call our office or email Mark or I at any time. And if you are interested in setting up a consultation, just reach out to Brian's team and they will get you guys set up with us as well with a few forms that we fill out and a free consultation. So thank you for listening, and we hope to hear from you with any questions.
Thank you very much, Mark and Jennifer. They came from Chicago to Maryland to bring us information that's very good for estate planning. The estate planning essentials tied with our first talk from local attorney Kevin Bress on the health directives are very good. If you have any questions, you can go to acresfinancial.com and again, ask a question on our website, or you can call us, email us. Get in touch with Acres Financial, and we can help you with any questions you have and get you in touch with the attorneys that you heard today. Neither of them work for Acres Financial. We're just associated with them, and we have vetted them over the years, and we enjoy working with them. They're very knowledgeable, and they truly, truly take care of our clients, which we thank them for that. This classroom session, the Winning in Retirement classroom session, is coming to a close today, and we thank you for listening to all of this. But we want you to be to stay tuned for in 2 more weeks on November the 12th at 4 p.m. We're going to have Casey Lynch from Evans Funeral Home and Jeff Akers. They're going to do a joint talk on prepaid funeral processing, prepaid funeral expense planning, things like that. And then Jeff is going to have a talk all by himself. Yes, we're going to let Jeff be by himself. And he's going to do a healthcare talk, pre-retirement healthcare and during retirement. How do you have healthcare? Where do you provide the healthcare? Where do you get it? What are the concerns you should have? He's going to bring that all together in a talk that'll be well worth listening to for those that are concerned about being prepared during their retirement years. Once again, we at Acres Financial Group, thank you for listening and watching this webinar we had today. This classroom session brought to you by Acres Financial Group, our Winning in Retirement classroom session. Be sure to listen to our radio shows on Saturdays and sign up for our emails that come out each Wednesday. Thank you for listening today, and we look forward to seeing you in 2 weeks.